Good afternoon, good morning, good evening, wherever you're based. Thank you so much for finding the time to join us today to the fourth session of the Transparency series. Today we will be examining how public funding contributes to pharmaceutical innovation and how the lack of transparency around this affects equitable access to medicines. To do this, we have a panel of experts that will present their recent research. But just before that, I would like to introduce the Transparency series. These are a series of webinars organized by Salud por Derecho, where we try to look at the different aspects related to pharmaceutical transparency. It is a space for civil society, scholars, and policymakers to join and debate around this issue, with the intention to bring the multifaceted challenges of transparency in this sector to the policy agenda. As I said, this is the fourth session, and we are expecting to continue with new sessions in the coming months, so stay tuned for more. Without further ado, I'd like to introduce today's panelist and moderator. Today we have with us Dr. Ayolola Eni-Olotu. She is a doctor and global health researcher based in Liverpool, UK. She has been involved in access to medicines advocacy and research through her various roles in Universities Allied for Essential Medicines, UAEM, particularly around the funding and accessibility of COVID-19 related health technologies. Ruiz Gil Abinader is a lawyer specialized in intellectual property and a law and policy researcher focused on intellectual property, technology transfer, and access to medicines. He has worked as a senior researcher at Knowledge Ecology International, has been a research fellow at Georgetown University's Center for Global Health Policy and Politics, and at the Interdisciplinary Center of Studies in Science, Technology, and Innovation. He has served at the Expert Advisory Board of the Medicines Patent Pool and comes with a vast experience in the intersection of law, policy, and access to medicines. Jaume Vidal is a political science graduate specializing in international relations with a 15-year career on public health issues. He is the senior policy advisor of Health Action International, and he leads Health Action International's advocacy and campaign work on access to medicines in Europe, including pricing, transparency, trade, and research and development. My name is Adrián Alonso Ruiz, and I'm a research and advocacy manager at Salud por Derecho. And I'll be very quiet, taking notes of the meeting and listening to our experts' opinions and views on this very important role. Without further ado, I'll leave Jaume moderating the session. The session is being recorded. You have the Q&A function in the chat, so feel free to pose any questions to the panelists or comments, and we will have a dedicated session after the presentations by the panelists. Thank you again, and Jaume, the floor is yours.
Thank you, Adrián, and thank you, Salud por Derecho, for convening this important event. I think that it should be highlighted that it's a series in the sense that it's not a one-off thing, but a continued effort to shed light on the issue of transparency, which it's a little bit like some sort of legendary beast. All of us, we are looking for transparency, but no one has found the way to make it work, to make it like transparency enforceable in a way that we can improve health outcomes, for instance. That's why this session is so interesting, because we are touching upon two elements that are equally critical: public funding, how to measure, how to evaluate, how to really guarantee the public return, and then patents, also known as the black hole of the legal framework. In the sense, all the information that contains a patent, how can we use that? How can we use like an instrument that allows for monopolies and exclusivities for the common good? Is there a way? And finally, and now it's the time for self-promotion, like we, together with BEMOS, we issued a report like a few months ago on the implementation of Resolution 72.8. If you remember, that was like 2019, that was the so-called Transparency Resolution. And all of us, we said, this is a milestone. This marks a before and after, like in the transparency in pharmaceutical markets. This report looks at what countries in the EU and beyond, like it includes like some Latin American and some African countries as well, how national governments have fared in implementing this resolution. What has happened and what can be done? I think that Adrián will share the link, and if not, I can share the link afterwards. But what is important, it's really how little has been done and how much there is still to be done, in the sense that we can see that there is an appetite in public opinion, in some governments, to go further, like guaranteeing transparency. But there is also a resistance on some governments, some of them really influential governments, and especially from industry. And I would like now to go back to what we are going to be discussing today. What we are going to be discussing today, it's like efforts from academia, from civil society, to shed light in critical elements of the access to medicines continuum. And I think that it's really important. I think it's not coincidence that Dr. Eni-Olotu comes from Liverpool University. Andrew Hill comes from Liverpool University. He's the one that really made like the cost of, like, remember the first EPSI treatments, like showing that there was like a really huge difference between what was being asked for the public to pay and what was the actual cost of these medicines. And also, I think that we are extremely lucky to have Luis Gil Abinader with us today, because like that's the problem, no? When we talk about like the professional like history of someone, it's like sound bites. But I mean, for me, it was like it's like the expert advisory committee of the patent pool. What does the patent pool? The patent pool negotiates licenses, and these licenses are a key to improve access, and patents play a key role. So you see, it's good that I'm the moderator today, because I'm the one with the less to tell you. So it's going to be 10 minutes each. I'm going to be super rich with the timing, because what it's interesting, it's not what we have to say, but what we have to hear from all of you gathered here. And I don't know what was the order, if it was Lola first or Luis. Lola, you have the floor. 10 minutes, please.
Great, thank you. I'll just share my screen. And just let me know if you can see my slides.
Yes.
Great, thank you. So thank you for the really kind introduction. So my name is Ayolola Eni-Olotu. I'm a doctor currently working in Liverpool, and I've been involved in the group Universities Allied for Essential Medicines. So we're a primarily student-led organization that advocates for the affordability and accessibility of health technologies that are derived from university research. And we've recently published a paper looking at the affordability and accessibility of COVID-19 related health technologies developed through research performed at UK universities. So I'll just move on to the next slide, if you'll let me. So the COVID-19 pandemic highlighted stark health inequalities, and access to medicines was no different. So here I have a series of maps showing the proportion of the population in different countries that had received at least one dose of the COVID-19 vaccine. And what we can see is that from quite early on in the pandemic, a large proportion of the population in high-income countries had received at least one dose of the vaccine. But as the pandemic progressed, progress was a lot slower in low and middle income countries. And ultimately, this meant that by the end of March 2021, 80% of the world's population had received only 5% of all vaccine doses, while the remaining 95% were largely hoarded and administered by high-income countries. While in low and middle-income countries, there were fewer doses given out, and this even affected vulnerable groups such as healthcare workers in these regions. And the consequences were disparities in mortality. So this map highlights the ratio of excess deaths, so beyond those expected during the COVID-19 pandemic, pandemic. And you can see that a lot of the countries in the global south were disproportionately affected. And some other consequences were that because it was a global pandemic, by preventing global control, there was increased spread of the vaccine, and that allows the emergence of COVID-19 variants. So you can see the consequences that affect us all when we don't look after the global community and we don't make sure that everyone's looked after. So in terms of what universities have to do with this and why Universities Allied for Essential Medicines does what it does. So universities are huge contributors to new research that develops in new health technologies. And a lot of this research performed by universities is publicly funded through the government and through different foundations. And while a lot of these health technologies originate from university labs, often they're licensed to third parties before they're brought to market in a process called technology transfer, which involves negotiations with third parties such as pharmaceutical companies. So this technology transfer process is an opportunity for universities to include in the conversation and the negotiations equitable access to mechanisms through different mechanisms and different terms of their licensing agreement. So UAEM has tried to appeal to universities and technology transfer offices and implore them to have equitable access policies that they formally commit to and publicly commit to. And some of the pushback we've gotten from that has been that TTOs haven't wanted to commit to an equitable access policy because they don't believe it gives them enough flexibility when it comes to what each health technology needs, so that a one-size-fits-all isn't appropriate. And we've also heard TTOs say that they don't need to commit themselves to a formal access to medicines policy because, of course, at the appropriate time, they would engage with these equitable access mechanisms. And many people would believe that a pandemic would be an appropriate time to utilize these mechanisms. So before I go on to the paper, I just want to highlight that there were a lot of different mechanisms available to facilitate affordable health technologies during the pandemic, such as the Open COVID Pledge, which was a COVID-19 specific Creative Commons license, the Medicines Patent Pool, which you've heard about, which does great work in facilitating non-exclusive licensing to allow less expensive versions of health technologies to be made available. There's an organisation called the Association of University Technology Managers, and they released guidelines for COVID-19 to support universities in using temporary non-exclusive licensing to prevent monopolies. The mRNA hubs, which facilitated knowledge transfer to allow rapid development of new health technologies in lower resourced regions, and the WHO COVID-19 Technology Access Pool, which was a collaboration between the Costa Rica government and the WHO, again to facilitate non-exclusive licensing. So for this paper, we looked at 35 universities that received over £1 million of public funding for health research and asked them, how did you license COVID-19 related health technologies? And how did you engage with the equitable access mechanisms that were highlighted in the previous slides? And we did this through freedom of information requests, so asking them for publicly held information, and through looking at the university websites to look at their technology transfer policies. So we found that from 2019 to 2023, 55 new COVID-19 related health technologies were developed by 14 universities. And for 41 of these technologies, exclusivity status was disclosed. So just over half of them were non-exclusively licensed over the course of the pandemic, starting at 62% in 2019 to 20, then going up to 75%, dropping to 18%, and then slightly increasing to 40% in the final year of the study. And the patterns and the exclusivity of the licensing did vary by technology type. So for example, for the technologies for which this was disclosed, vaccines were only ever exclusively licensed. Diagnostics, therapeutics, and personal protective equipment, such as gloves and masks, were initially non-exclusively licensed and then exclusively licensed in later years. In particular, the majority of therapeutics were exclusively licensed. We also looked at tools, which we described as new IP that could be used to develop future technologies. So for example, these were specific COVID-19 antigens or pieces of equipment that were developed for the purpose of creating new diagnostics or therapeutics or vaccines. So you can see the pattern there, and the pattern bars highlight the non-exclusive licensing over the course of the pandemic. We also looked at patents. So over the course of the study, there were 36 patents on new COVID-19 related health technologies. 35 of these, they disclosed where they were filed. So a majority, about 70%, were filed only in high and upper middle income countries, while the remaining 31% were filed in lower middle and low income countries. And for those that were filed in low-income countries, this was largely done through a patent cooperation treaty, which allows simultaneous patents to be filed. And in terms of policy changes and engagement with the highlighted access mechanisms, only 2 universities made access-related changes to their technology transfer policies. So Manchester adopted something called the Affordable Access Plan, which is essentially a provision that means that during the technology transfer process, they need to consider equitable access. And the University of Edinburgh initially released an essential medicines policy that put an emphasis on equitable access to medicines. However, they later said this wasn't feasible, revoked it, and released a less committal statement of principles. One university signed on to the COVID-19 guidelines that I highlighted earlier, and no university is engaged with the Open COVID Pledge, the CTAP, BP, or the mRNA hubs over this period of time. So some challenges to this study were a lack of transparency. So for example, the University of Oxford didn't disclose the nature of their licensing for any of their health technologies because they said that it compromised their commercial interests. And we were also reliant on the university self-reporting. So these findings are dependent on what the universities have said. So for example, they may have engaged with some of these equitable access mechanisms, but we can only rely on what they've told us through the Freedom of Information requests. But overall, in terms of our conclusions from this study, we've seen that universities are capable of rapidly producing innovative technologies during a pandemic, and they are a critical part of the pandemic response and of new R&D in general. There were several mechanisms available for them to engage with to facilitate equitable access, but there was a widespread lack of engagement. While non-exclusive licensing was used by a very slight majority, there was a sporadic use of these, and it was inconsistent, and there was no widespread systemic change to prevent monopolies on these new health technologies. So overall, there was a lack of systemic change in response to a global crisis, and this crisis required a timely response to enable equitable rollout of these technologies. So essentially, this situation occurred largely in the absence of formal commitments to engage with equitable access mechanisms, which limits our ability to hold universities and technology transfer offices accountable in situations like this. So this is part of UAEM's mission to ensure that they commit themselves to engaging with these mechanisms so that at a time like this, we can know that universities will take the avenues available to ensure that their innovations are equitably accessible. So that was just a quick run through of our findings. So thank you for listening, and thank you to my co-authors and to the authors of the first paper from the first year of the pandemic.
Thank you, Lola. I think it was not only on time, but really full of stuff that we are going to be addressing later on. I think that the articles are being put in the chat, so you can access them now. And yeah, let's also now listen to Luis, and then I will do a little summary and we start the discussions. Luis, you have the floor.
All right. Let me see. Are you seeing my presentation now?
Yes.
All right. I saw that everyone was putting QR code, so I added a QR code to my presentation just right now. I think it works. It helps if you read the article, but it's also helpful if you tweet about it. I think this journal tracks whether you tweet about it, so that's useful also, or use Blue Sky, which is maybe even better. Okay, so in the United States, the Vidal Act requires grantees of federal funding to put a statement in their patents that acknowledges that the invention that was sort of claimed in that patent was funded by the US government. And if the grantee complies with that requirement, it would appear sort of like this. A statement with 2 sentences. The first one that would identify the grant that led to that invention and the federal agency that provided that grant. And the second sentence will simply acknowledge that the US government has certain rights on the invention precisely because it funded parts of or the invention itself, the research that led to that invention. Timely acknowledgement of federal funding like that helps government agencies and the public in a number of ways. First, because it is helpful to trace contributions towards biomedical innovation, and with that information, the government can also inform future decisions on investments towards biomedical innovation. In my experience working with dozens of pharmaceutical products throughout, the years, every time we propose, or civil society propose something related to lowering drug prices, whether that's compulsory license or what have you, pharmaceutical companies come back with essentially, it's almost guaranteed that pharmaceutical companies will use one argument as part of their tools of narratives to push back against that sort of proposal, which is that they themselves invested in the research and development that led to that pharmaceutical product. The reality is that oftentimes the public and the governments have put in most of the time, important amount of money on the research and development that led to that product. And so if we have timely acknowledgement of federal funding, that helps the public and the governments sort of distort that, or rather curve those distortive narratives about relative private and public investments in research and development. It is also helpful to determine when there is the case for a margin rights and a royalty-free uses that apply under the Vidal Act in the United States. It is also useful to monitor compliance with other policies related to or that govern federal research. For example, the NIH has a policy related to the preference for non-exclusive licensing of research tools. If there is a timely acknowledgement of federal funding, then we can at least begin to track whether that patent is being licensed non-exclusively. There's more that needs to be done to be able to have that information, but at least this is one step towards that. And a timely acknowledgement of federal funding is also useful to negotiate lower drug prices with pharmaceutical companies. The problem, of course, is that a lot of the times the patents that are federally funded and therefore require a government interest statement often don't have it. This is from my paper, and you can see that in the early years of the implementation of the Vidal Act, less than 70% of the patents that were required to have a government interest statement had properly complied with that requirement. In earlier years, the grantees have increased compliance, but they're still not perfect, right? Even in recent years, like 2020, there's more than 10% of the patents that we know about that should have included a government interest statement failed to comply with that requirement. And there's also another problem related to that one, which is that oftentimes grantees initially failed to disclose government funding in their patents, and then years later, they acknowledge government funding through a thing called certificate of corrections, which looks kind of like this. And as you can see in this graph, some of the times that delta between the filing of the patent and the acknowledgement of government funding extends to more than 10 years. So for that amount of time, the public didn't have all the tools to confirm that the patent was subject to government funding and therefore subject to the Vidal Act safeguards and other provisions in US federal law. So then the key question that I try to address in my paper is, why do grantees initially fail to comply with government interest statements requirements, and then they eventually acknowledge that the US government funded their inventions through this thing called certificate of corrections? And this is the most important contribution of my paper is summarized in this graph, which is a chronological analysis of all the certificate of corrections that I found. And as you can see, there's been about 3 spikes throughout the years in the issuance of certificate of corrections. The first one in the early 1990s, which you can see there, and in the paper, I point to 4 factors that I think can explain each of those 3 spikes. The first one is a high-profile controversy between a California institute named Scripps Research Institute and the U.S. government. The second was an oversight by the U.S. government that happened sort of like a follow-up from the initial controversy. There was a change in the regulation that led to this big spike starting in 2016. But most importantly, the thing that I want to talk about the most, because we're in civil society, and I think that's the topic that sort of that we wanted to talk the most about in this presentation. You can go back to the paper and read about the first 3 factors that I mentioned, but I want to talk more about the civil society advocacy that led to this. That was at least one of the factors that led to this big spike in certificate of corrections starting in 2016. And Jaume mentioned that I used to work with Jamie Love and Knowledge Ecology International. And of course, this presentation is on my individual capacity, not on behalf of KEI, but I have to mention that work. Jamie Love has been working on failure to disclose for more than 30 years. And at around 2017, KEI ramped up its work on failure to disclose. And starting in that year, KEI has filed more than a dozen reports with the U.S. government describing what appears to be a failure to comply with BIDOL disclosure requirements. And that included dozens of patents, because each report had usually named 6 or 7 or more patents. Some of those reports were completely ignored by everyone that should have read it, but others reports were had a lot of coverage and had a significant impact. For example, this report in 2020 about apparent failure to disclose government funding in patents owned by Moderna was covered by the Washington Post, which is an important news media outlet in the US, and also had repercussions in the US Congress. For example, Senator Chris Van Hollen tweeted about that report. And that report led to an investigation by the US government, which then eventually, 3 months later, led to the correction of at least one of the patents that were mentioned in that report by KEI. And so the efforts that KEI has led has led to specific corrections that we can point to, which are patents that are named in the reports that KEI have published. But also, it appears that the efforts that KEI has been leading has also led to corrections of patents beyond the ones that are mentioned in the report. 2 of the universities that KEI has highlighted in reports about failure to disclose government funding in the patents are the University of Pennsylvania and the University of Pittsburgh. And just shortly after KEI published a report about each of those universities appear to have gone through a review of their entire patent portfolio and issue correction in batches. So they corrected, in one case, more than 50 patents, and the other case, more than 20 patents in just 1 year, which signals that they went through a review of the entire portfolio and made corrections. And it appears that the KEI reports had to do with it. And this is on the last slide here, 2 slides to conclude with some lessons. The first one, and this very much touches on things that Jaume was mentioning at the beginning, which is that, yes, we love to have a resolution by the WHO on transparency, and we love to have laws on the book in different countries about transparency in the pharmaceutical markets, or at least different dimensions of the pharmaceutical markets. The Vidal Act, for example, touches patents. But we need to recognize that by themselves, those legislation may not have a full impact. We need to recognize that civil society advocacy will be needed to continue to increase compliance with transparency obligations, even when there's a legislation on the books. And this is what shows with the KEI advocacy. This is Vidal obligation to disclose have been there for more than 40 years, but it wasn't until KEI jump in and some other factors that I explained in the paper that compliance has increased. And the second lesson that I want to highlight, this is the final slide, is that there should be mechanisms to enable civil society to request a fact-finding process to investigate apparent failure to disclose government funding and other failure to comply with transparency obligations. Think about third-party patent oppositions. In many countries, it is possible for civil society and other third parties to go and tell the patent office, look, you shouldn't grant this patent because it doesn't comply with the patentability criteria. And in some countries, those third-party patent oppositions are binding, meaning that the patent office have to actually look into them and reply to the objections that are made by the third party. Again, as I mentioned, some reports made by KEI had an impact, others were completely ignored. And we need a formal process to go forward and tell the governments of different countries, look, there is a transparency law and there's a violation of that law and you need to investigate that. And that has to be a binding request. Thank you. Again, the QR code that I mentioned before, it helps if you read and it helps if you tweet or blue sky about it. And thank you so much.
Thank you, Luis, for sticking to time and also for expanding the scope of the discussion and I think it's really a very complementary way with what Lola was saying. I don't know if you listeners have shared your questions in the chat. Are there any questions? Okay, then I'm forced to inflict my questions on the speakers. I think it's very interesting what Lola was saying, it was very clear, how universities were dealing on the management of these public funded researches. And I think it was interesting to see that the evolution, how the non-exclusive arrangements increased or decreased in a 4-year period. For me, what it's interesting is to see, or really to ask, what was the role of UAEM in this process? Because it's clear there was an intervention by an actor there. I mean, this dynamic didn't change by themselves. So that's my first question, and then we can engage this, and I will have another one for Luis. Lola, you have the floor.
Yeah, thank you for the question. I agree, it's a really interesting pattern or even kind of lack thereof. So we can see that some universities did choose to engage with non-exclusive licensing. In terms of the drivers for this, I think it really varies by technology transfer office and what the kind of local culture is in terms of if they've used non-exclusive licensing in the past, if it's something that they feel comfortable with. But what we try to do within UAEM is to highlight that students are stakeholders in this conversation and they're part of the academic community, and that we should be able to speak about the impact that our universities and our university researchers are having. And we try and let TTOs know that someone is looking at this. So we've been kind of asking these questions year on year and showing that we have interest in where these technologies are going, I think has a serious impact. In terms of what we do at a local level, we try to meet with these technology transfer offices and make them aware of the different mechanisms that are available. We've gone to meetings where there are associations of technology transfer offices, again, just to make them aware of this kind of stream of work, because unfortunately, equitable access isn't something that comes up in the conversation all the time, and we try to make them aware that they should. So it's encouraging to see that there were TTOs that chose to engage with this during the pandemic, but we know that they can do better. We know that there can be more systemic change, and we know that it will be easier if equitable access is something that's integrated into their local processes rather than something they choose to do if it feels appropriate at the time.
I think it's quite key, no? In the sense this ad hoc element that some of the policy changes look like. And now I would like to ask Luis something that I think by now we have realized it's like the limitation of the voluntary measures. In the sense we see it with like private companies disclosing like the amount of public funds or like governments disclosing the price they have paid. It's always on a voluntary basis. And the issue here is like we see that this is like also not affecting, but it's also to be found in other forums, like for instance, like the pandemic accord negotiations, where we see that the Europeans ask that anything like related to tech transfer or IP management needs to be on a voluntary basis. And I would like to ask Luis in the sense of like how civil society advocacy, how can we attain like the enforceability in the sense how can we convince governments to legislate in such a way that they hold effectively private actors accountable?
Yeah, thank you, Jaume. I would say first one thing in the case of the Vidal Act and the disclosure requirements on patents that emerge from the Vidal Act, that is not voluntary. That's pretty much mandatory. And we can think about it as a conditionality. Every time someone gets money from the federal government, not every time, there's some exceptions, but almost every time, it is required to have that. And that conditionality comes from the law, it comes from the regulations. And by the way, every time a grantee signs a contract, the contract has that provision too. The reason why there's so many failures and so many late disclosures, one of the key ones, I think, is because the NIH has historically said, we will not take your patents if you fail to disclose. We want to work with you. We want you to comply, but we will not take the patents. That is something that is described in the paper too. And so that policy of sort of like not wanting to take the patent, even though there's a law that requires disclosure, has led to lack of, one of the factors that has led to lack of disclosure. So maybe what I'm trying to say here is that I think there has to be consequences to failure to comply with transparency obligations. One key consequence that we can work on in the case of failure to comply with statements in the patent is losing patent rights, right? And the government's grant those patent rights, the government can take those patent rights. And my analysis of this thing, and I would maybe take the opportunity here to mention that we will be talking about this again in Amsterdam in about 10 days from now. And maybe we can sort of like, talk about the conditionality angle a little bit more. But in my interpretation of the TRIPS agreement, for example, which requires countries to make patent rights available, but not to give those patent rights and preserve those patent rights, it means that you can put conditionalities like this, that you can put requirements like, for example, disclosure of government funding and take those patents if they are not complied with, and that's okay. I think that addresses your question, Jaume, maybe, or?
Yes. And I think it was an important correction in the sense that the Date Boyle Act is compulsory. It's not something that companies can choose to obey or not. I think that there is a question in the chat.
I can address it here if that refers to the Vidal Act.
Yeah, so there's a few questions in the chat, a couple of them referring to whether there are other countries where these disclosures are mandatory by law.
There's another one before that.
Oh, sorry, I didn't see that one.
Yeah, where else in the world are these disclosures mandatory by law?
Yeah, that is a great question. That is a great question that allows me to make a sort of a broader point about this. The Vidal Act was enacted in the United States in 1980, right? And ever since, there have been an effort I think that there was a big spike in the 1990s, a lot of conversations about the Vidal Act being awesome, and there's being a need for other countries to adopt similar laws like the Vidal Act. And that's when the Economist, for example, in I think 2001 or 2002, said that the Vidal Act was one of the most important legislation in the history of the U.S. So that was this like there was this effort to export the Vidal Act to other countries. The interesting thing is that there was a cherry picking process in what provisions were exported and what provisions were not. And so, for example, India and South Africa have legislations that are similar to the Vidal Act, encouraging the patenting, in other words, encouraging the privatization of publicly funded research. And yet, I don't think neither of those countries have disclosure requirements. So they were exporting, as far as I'm not aware of any country that exported the disclosure requirements in the Vidal Act, but I could be wrong, but I don't think, I'm not aware of any country. And so this is a pretty big mistake, I think. We need to be requiring governments to enact this type of legislation. I think there's a space in Europe, there's a space in other regions of the world to enact similar disclosure requirements, especially because many of those countries have been talking about the Vidal Act and importing features like other features of the Vidal Act in their own legislation. And maybe I'll read what this, should I try to answer the thing that this is talking about?
Yeah.
I think I mentioned, I addressed the first point. Yeah, the second point, that's a good question. I'll answer it now. And then government hold, yeah. Okay, so the point 2 and point 3, thank you, Dis, for those questions. He asks, do research funders keep a list of the patents that have resulted from the grants? And do governments have a list of patents that result from the grants? The answer is yes. And that's actually the data set that I mentioned in my paper, and the data set that I was able to use to understand failure to disclose a little bit better. So there's a data set that is currently, at least for now, we don't know how long it's going to be published by the NIH, called Reporter, which include the grants that the NIH has granted to folks for research. And then there's a sort of a table in that data set that lists all the patents that the NIH knows about. The limitation is that the NIH only has a list of the ones that they know about, because the patentee or the grantee comply with the disclosure requirements. If a grantee does not comply with the disclosure requirements, then neither the public nor the government knows about it, and therefore it will not appear in that list. So that's a big limitation. But yeah, that is public, and this, it is mentioned as one of the data sets that I use in my research. If you want to have it, I know you're interested in empirical research too. I can share it with you.
Good. We have like other questions, and that's something that I would like to also recover, that it's like patent opposition, in the sense that it's really interesting that we sort of complain that patents are extended, that there's like evergreening, that there's really a clear obstacle for access, but we forget that we have a role to play before the patent is granted. And we have some very interesting efforts conducted by civil society. We have the International Treatment Preparedness Campaign that have been doing patent opposition in several countries. Also, Médecins du Monde have been working with the European Patent Office to examine a little bit like the processes. And I really like that. You see, now that we are like 45 minutes into the event, now that we are friends, you can see like the word is freer now, and we are like talking among friends. And I think it's very interesting what Christian is referring, in the sense, what would be the need for patents if we had public pharma? And I think it's interesting because I know that it sounds, hey, patents have been around since always, but it's not the case. I mean, you have some countries in Europe, like for instance Spain or Italy, that had really like big public pharmaceutical manufacturing sectors, and pharmaceuticals were not like covered by patents. And now there's also like a new impetus, new push for a public pharma in Europe. Maybe Christian, you have the link to this public pharma alliance that it's been on its first year anniversary like yesterday, I think, which is really kind of it's momentous. And I would like to go back to Lola. I think it's something she said that was really interesting. It said like all the inequities in access to COVID technology, and you mentioned like several initiatives that were like set up, no? And we had the COVID-19 Access Pledge, and we had CTAP, and we have the mRNA Tech Transfer Hub. And now we are 2025, where we are at with these initiatives in terms of transfer of technology. If universities have really stepped up in the sense like, yeah, we're going to really fulfill what we mentioned, or these efforts, as many related to pandemic, have like fizzled out. And then I think that Adrián has questions and comments as well. Lola, you go first.
Yeah, I just wanted to say I completely agree with your point. I think in terms of where universities have taken things forward, the issue is that we looked at how technologies were licensed individually, and as we can see, it was on kind of an ad hoc basis, so it wasn't reflected in changes in the university's policy. It's disappointing that out of the 35 universities, only 2 updated their policy to account for access to medicines at all. And again, you'd think the pandemic would provide conditions for universities to be considering equitable access and how they can implement it moving forward. So in terms of what we did within UAEM, we did feel like COVID-19 gave us good momentum to restart these conversations with technology transfer officers. But as we've moved away from that, it's been harder to bring up the importance of equitable access again. And it shouldn't be that way, because the access to medicines crisis is ongoing, not just in a pandemic environment. So we are really advocating for systemic, but also sustainable change in the way that technology transfer is done.
Thank you, Lola. Adrián?
I'm gonna abuse my privilege of organizing the meeting to ask a question to Lola. By the way, excellent presentations to both of you. I was very interested about the example that you mentioned from the University of Manchester and the development of an affordable access plan by them, Lola. And I was wondering if you've seen, or if that, in your experience, has kind of spurred some kind of action within the university landscape in the UK. Has that been taken forward by any other unis, or have you used it as an example to be exported to other universities?
Yeah, the Affordable Access Plan is really exciting. I believe it was developed by MPP, and it was first initiated in some US universities with the involvement of UAM members over there, which is really great to see. And from what I've heard in the States, they've faced very little issues and very little pushback from the commercial sector through using it, which is really encouraging. So we've used those kind of testimonies to speak to UK technology transfer officers. And yeah, the UK TTOs are really interested in it. So Manchester's adopted it. Several technology transfer officers are trialing it. Again, we've tried to encourage them to make public statements about it, because we know that these TTOs influence each other, because they're very research intensive universities that are trying it. So I think quite a few universities are in a trial period, and there's hopefully a wave of it. And there have been some recent panels within an organization called 10U, who are an association of technology transfer officers who regularly host events discussing social impact and technology transfer. So we've also spoken to them as an organization about the Affordable Access Plan. So these conversations are ongoing. I think what we need to see in the coming years is where the AAP has been used, and we really want to encourage TTOs to speak with each other about their experiences with it, because it does seem like there's this hesitancy and this fear that universities have, where they don't think that they can push for equitable access because they don't believe that they have the amount of power that we believe they have. So it's good to see that the AAP is being trialed and it's being used, but we hope to see it become a bit more of an open conversation.
I don't see any other questions in the chat. Luis, I've seen a comment by Elena Villanueva asking if you could share the data set. I can put you in touch if you don't know each other already. It's great to see what happens when you make information public good. So I think we are about to end our time. And if there are no other questions, obviously, if you have questions that you didn't have time to ask, or you think about them after we end the meeting, feel free to reach out to us, and we're more than happy to put you in touch with Lola or Luis or Jaume. Before we close the meeting, I would like to thank Luis, Lola, and Jaume for their amazing contributions to the push for transparency, and above all, for being today with us and share their experiences and knowledge with the broader community. Thank you everyone for joining on a Friday. At this time, at least in Europe, most people start leaving their offices, so that's really appreciated. In other parts of the world, it's even weekend already. So thank you so much for your time and for being here with us today. As a couple of mentions regarding the discussions that we've had today, I just wanted to mention a theme that has come up in other sessions of the transparency series that we've held, which is this kind of Janus phase of the state, one that on the one hand, it's able to promote the transparency resolution at WHA, the NIH access plans in NIH-related R&D funding, or the example mentioned by Lola today from the University of Manchester. But it's also a state that it's able to push back many times, and we shouldn't forget about that. One key point that keeps emerging over and over in these sessions is the essential role of civil society in ensuring drug transparency and transparency in the private sector. Super interesting to learn the different methodologies that Luis and Lola and other people in UAEM have been using, such as the use of freedom of information request to expand transparency from the public sector. So let's continue the conversation with that, the notion that civil society and academia are essential players to increase transparency, and hopefully we can reconvene in a few weeks or months for our next session of the transparency series. Jaume, do you want to say any final words before closing?
No, just thanking Salud por Derecho and all the participants today. I think that we did a little step forward, so it's good that we keep on working. Thank you.
Thank you very much, everyone. Have a good weekend ahead.